Everybody. Um, we start now with the contributor talks of this afternoon. Okay, we'll have 3 contributor talks, and then we'll close the day with a little panel discussion involving all of the speakers of this morning. Okay, in this contributed talk session, we'll have 3 talks that, in some sense, will nicely add some new aspects to the discussion. We'll start with a legal perspective, right? We talked a little bit about some of the copyright implications that all of these generative AI systems have. And obviously, if we're talking about copyright, we're also talking about agency and then what these models actually are. Are they creators or not? We'll talk a little bit about the judgments of beauty. We'll try to quantify that a little bit. And finally, we'll also talk about creativity as a virtue, which I think is another aspect that we haven't really touched upon so far. So without further ado, Giovanni, thank you for joining us, and take it away. Say something?
Okay, yes, great.
15 minutes and then 5 minutes.
Yes, thank you. Good afternoon, everyone, and thank you for being here. Today we'll address a topic at the intersection of law, technology, and creativity: the application of European copyright law to artistic works generated with the assistance of AI models such as ChatGPT or Midjourney. In light of the current regulatory gap, I will explore how courts, through judicial interpretation, will handle the problem at stake. And once done this, I will also consider possible path that the European legislator could take to regulate such a complex scenario. Before diving into the core of the topic, let me briefly explain what we mean by copyright. In a European legal tradition, copyright is a legal right granted to the author of an original work, recognizing and protecting his intellectual and creative contribution, including its economic dimension. It arises automatically upon the creation of the work and grants the author exclusive rights to reproduce, use, distribute, and control his work, as long as some conditions are met. This condition we will analyze very soon. At the European level, copyright is primarily regulated by several directives. However, none of these regulate explicitly AI. In fact, all of these directives were conceived in a pre-AI era and have very strong anthropocentric focus. In fact, the core point of all copyright legislation is that there is a human author. Therefore, it is of crucial importance to understand whether we can say that a work is created by a personal author or by a machine, let's say. This anthropocentric point of view, it is clear if we consider the 4 requirements that are necessary to be protected with copyright, that are the fact that the creation must qualify as a work, it must result from human intellectual effort, it must be original, and it must be expressed. Now we will briefly address and explain these 4 key topics, and then we will verify if this concept could be applied even if we are in front of work generated with the assistance of an AI tools. Starting with work, we have to highlight the fact that there is no general definition of work in EU legislation, but the term generally refers to creation within the literary or artistic domain. European law has explicitly harmonized the protection for some categories of goods, even in the digital domain. Nevertheless, it never addressed AI output. Sorry, I don't know, the chair. The second requirement concerns human intellectual effort. The Court of Justice case law consistently relies on the notion of the fact that a work must result from a human engaging in creative activity. So it is necessary that the human makes creative choices and do not rely only on mere technical abilities. So this is the requirements that most reflect the anthropocentric point of view. In fact, the core is that copyright safeguards human expression and not other type of expression. The third criterion is originality. According to Court of Justice case law, a work is original if it reflects the author's own intellectual creation. So the work must result from personal and creative choices rather than mere effort or technical skills. In fact, even if there is some external constraint, such as technical tools or other kind of technical limits, the work could be original if within these boundaries the author could express his own creativity, his own intellectual original effort. And therefore, the personality of the author must be expressed. But finally is expression. Oh, sorry. Expression that is essential because the human creator's creativity must be expressed. The copyright does not protect ideas themselves, but only the way in which these ideas are concretized. Whenever conveyed through language, form, data, color, or other kind of tangible means. In fact, the use of creative freedom must be perceivable in the work's expression. In fact, there must be a causal link between the creativity of the authors and the way in which the work is expressed in the final forms. These legal principles are the primary reference to understand if there is copyright over a work or not, and now we have to understand if this principle could be applied even in the absence of a specific regulation regard the fact that the work is produced with the assistance of an AI output. So let's begin with work. As mentioned earlier, the work is a requirement that it is relatively straightforward to satisfy. In fact, it's clear that an AI-generated output that is, for example, images could fall within the artistic or literary domains covered by the Article 2 of the Berne Convention. So basically, fall within all the EU regulations that cover these situations. Even the human intellectual effort is a requirement that it is easy to meet. In fact, the Court of Justice clarified that the use of tools or devices does not exclude authorship, as even only if the human exercises creative choices. The AI-assisted works must be characterized by the involvement of human intellectual inputs, and these inputs could be of different types. For example, it is enough to setting specifications or supervising the creative process or even to selecting prompts. Nevertheless, it is important to emphasize that fully autonomous AI output could not fall in AI in copyright protection because there is no human intervention. So yes. So the key question is to what extent must human contribution be present for a work to qualify it as an intellectual creation? To answer to this question, we go to the third and the most crucial criterion, that is originality. The focus is on whether the human creator has a sufficient creative control rather than complete control over the final outcome. In fact, this requirement is met if the author was able to express creative abilities in the production of the work by making free and creative choices. These choices could be done in a different part of the creative process. In fact, the Court of Justice distinguishes three phases of the creative process in which we can find originality. These phases are the conception phases, the execution phases, and the reduction phase. The conception phase goes beyond merely formulating a general idea. It requires a series of detailed design choices, for example, the tools that is chosen, or the style that the author wants to follow, or the technique that will be used. In this phase, AI functions just like an external constraint that limits the human creativity and the human freedom, but it is a phase in which there are a lot of space for human creativity and human originality. The second phase is the execution phase, and that basically is where the actual production takes place, converting the design or plan into a draft version of the final work. This is the phase in which AI is more important. In fact, it challenges the idea that AI is just a tool. In fact, AI creates on its own an output. The last phase is the reduction phase, that it involves refining and processing the draft into a finalized cultural product ready for publication or distribution. And this is the phase in which the human verify the output, control its quality, and so on. The Court of Justice has emphasized that the creativity must be present in just one of these different phases. So it is not necessary that the originality and the creativity is expressed with the same degree and in the same manner during all these phases, because it's just sufficient, for example, that the conception phases and the reduction phase are characterized by a lot of creativity and human effort, but the execution phase instead is based on just the AI activity. Okay. Yes. Lastly, yes, I make a little big mess with a slide. The last requirement is expression. So the court has indicated that even unintended expressive elements may be protected, provided they align with the human author's general creative input. So basically, if a human guide the AI toward a particular artistic vision, probably it will be protected by copyright, even if the output will not be premeditated, let's say. In fact, the unpredictability that characterizes the AI does not necessarily exclude the work from protection, because it is enough that there is at the real beginning conception of the final work, and between big lines the output will follow the initial idea of the author. So, who owns the right where there is minimal or ambiguous human input? According to these principles, the Court of Justice retained that the ownership is on the user. This is a way in which the anthropocentric point of view that characterizes EU legislation is respected, and is also a way that reflects the idea that the user exercises creative control, and this is the AI is just a tool. Nevertheless, we have to emphasize that there are other models of ownership that are the developer ownership, the joint ownership, and the public domain solution. Regards the developer ownership, basically it means that the software developer has the copyright, and the rationale behind is that developers play a crucial role in the creation of the work. So basically, he is the real creator, let's say, of the work, so he must have the rights to use it. This is for sure a good idea, but there are some problems. The first one, the difficulty in finding who is the developer and who could be considered as a developer. And the other one is that actually AI has not legal personality. So we for sure have to identify a person that are different from the AI. And this could be a big problem in legal terms. The other model of authorship is joint authorship. That is a very good idea because basically it consider the output as something that is created by two entities that are one the human and the other one the AI, but there is the problem of the absence of legal personality of AI. So another time we have a lot of problem if we follow this path. And the last idea is the public domain solution. That basically thinks that we cannot protect AI-assisted output with copyright because from the one hand, AI are based on information, data that are that come from other person, and we don't know the influence of this other data on the final outcome. And the other fact is that we cannot establish the degree of involvement of the user. So basically, no copyright rights, no copyright for this kind of solution. Each of these models could be led to some benefit, but also have some drawbacks. And so the best solution is, sorry, I forgot to. The main solution is to use the positive elements of every of this model. In particular, I think that a good idea could be use a dual model. That is one, from one side, recognize the copyright for human that use AI, if he can prove the requirements that we are described before. But if he is not able to prove that, the outcome should be in open access to avoid the risk of an unjust use of the output. Thank you for your attention, and thank you for being here also.
Thank you. Very interesting. We have time for a couple of questions. Yes, let's start here.
Thank you for your presentation. As we have seen earlier in the presentation that someone asked AI to generate the painting on itself, like without the input. What if AI generates the image which has some maybe illegal thing, some blasphemy, some any other thing which can be under legal circumstances? So who is now liable here? Because the person said, okay, do it yourself. So he didn't enter the prompt. So in this case, what happens? Like,
Yes, this is a really good question, and it's a very, very big problem. In fact, at the moment in European Union, there is no rules on this topic. So basically, we have to follow the rules of every single member state, and it's a big problem if we consider the dimension of the AI phenomenon. Nevertheless, we can say that the crucial point is to determine whether the outcome, the output is something that is unpredictable and unpredictable or not. If it is yes, the user has no problem, is not liable. Otherwise, it could be. But we have also to highlight one fact. There is no liability if there is no damage. So if there is no damage because there is just an image with some bad stuff, there is no problem at the end because no one suffers from a damage. And if someone suffers from a damage from the output, it is also important in which manner the output damages the person. Because if it's just a picture that I created but I send to all of my contacts, it's clear that the problem is not the AI output, but is how I used it. There are other cases in which it's more complex to determine if the liable person is the user or AI, but generally we have to stay focused on these two main aspects. You're welcome.
Yeah, another question from Mason.
Hi, thank you for the talk. So I think one of the things that people think about in the popular sense when they think about AI copyright is, if the AI is recombining things that might be, someone's intellectual property, and you see, like, you ask for something and it produces Star Wars characters or Disney characters, yes, and in new settings. If a human did that, then they're they might not be able to copyright that work, or they might get sued by Disney or something like that under some law. But then, as you kind of consider the limiting cases, the specific influence of any of these copyrighted data that are in their training set becomes smaller and smaller. It becomes less and less obvious. And so I'm curious about how you think about where the law is at in terms of finding the threshold of sort of specificity of the dependence of the generated output on certain copyrighted works before that output becomes no longer copyrightable in principle.
Yes, even this one is a very good question, and it is a very complex to answer very briefly. But for example, in the European Union, there is a new law that is called AI Act, Artificial Intelligence Act, that is a comprehensive regulation of directive, of the AI realm, let's say. And because of the fact that it is too complex to verify which image is protected by copyright was used to train the data, and in which manner there is the influence of one copyright protected image or another one, they impose to the big tech or the, company that create AI tools to comply with a lot of requirements in terms of copyright. So basically, if you want to operate, they must comply to a lot of aspects, like, if you use some registered book, I don't know how to say in English, but some books that are yes, under copyright, but yes, under copyright, you have to prove that you have by the copyright for its training. Of course, there is some way to make this process easier. For example, they pay a forfettario amount, I don't know what. Yes, advance. Yes. So without have to pay for each right, but in a comprehensive way that it is good even for their economical needs. But yes, they adopt a preventive approach rather than ex post, because it's more complex to sue someone for damage than asking him to comply with some laws.
All right, thank you very much for this little excursion to law. And so now we move to our next contributor talk.